Mr. Justice Douglas, and may it please the court, I move the admission pro hoc vacay of A. Raymond Randolph for the purpose of arguing this case. Mr. Randolph is a member of the Bar of the State of California and a member of my staff, and I recommend it at the court. The vote is right. Okay, I'll prove this vote. You ready? Opposite. Of the goose. Well, the cup to. You, Justice Douglas, you may it please the court. The matter now at bar involves the seemingly unrelated provisions of the Securities Exchange Act of 1934 and the Youth Termination Act of 1954. These two seemingly unrelated statutes are drawn into focus in this case because both of them involve prohibitions against overreaching, and both of them create limited fiduciary obligations with respect to those who are subject to their provisions. The Youth Termination Act of 1954 has the effects of dividing the Ute Indian tribe of the Uinta and Ouray reservations into two entirely artificially created groups, and directing that all of the assets of the reservation, including in particular, as far as the fact that this case were concerned, beneficial interests in the mineral estate, were to be divided between the two groups and to be distributed to the Indians about to be terminated. Now, I note in passing that those who are responsible for the drafting of this law have referred to the group that was about to be terminated as mixed bloods. The term mixed blood is itself a slur, and it is offensive to the petitioners in this case who prefer to be referred to by the term terminated youth. The petitioner-affiliated youth citizens of the state of Utah is the authorized representative of all the terminated youths, which was formed in the manner specified in Section 6 of the Youth Termination Act by a constitution and bylaws which was duly ratified by the majority votes of all of the adult terminated youths at a special election called by the Secretary of the Interior.
Why the statute, of course, talks about mixed blood, and the only terminated youth are those who were referred to in the statute as mixed bloods.
That is correct, Mr. Justice Stewart. When I made reference to that circumstance, what I had in mind is that in reality, if we want to talk in terms of the ancestry of the Indians on this reservation, all of them are indeed mixed bloods.
Well, I sort of make it helpful to talk in terms of the statutes.
Yes.
And the statute does use that phrase throughout.
It does, Mr. Justice Stewart, and my point simply was this. The term itself is offensive to the petitioners, and they have designated themselves otherwise. And
well,
the statutes that so provide. No one in these proceedings disputes that the Affiliated Youth Citizens was the organization which was formed in the manner specified by the statutes. There is, however, a rival organization which we will discuss in some detail in these proceedings, known as the Youth Distribution Corporation. The Youth Distribution Corporation is a corporation formed under the corporate laws of the state of Utah. It was not formed by the adoption of a constitution and bylaws. It was not ratified by a majority vote of all terminated Ute Indians, nor was it considered at a special election called by the Secretary for that purpose. Thus, the crux of the problem in this case, vis-a-vis these two rival organizations, is the question of how the powers of the authorized representative could have been transferred from the affiliated youth citizens, who admittedly were originally invested with those powers, to the Youth Distribution Corporation. It is thus a conveyancing problem, plain and simple. And I invite the court to pay particular attention to the manner in which it is proposed that those powers were shifted from one organization to the other. The question turns on the definition of authorized representative as contained in the Act. We're not concerned, for the purpose of that definition, with the question of ownership of property. Section 10 of the Youth Termination Act, which is the section which defines the authorized representative powers, refers exclusively to the question of powers to manage the jointly held and restricted assets of the two groups of Indians in the mineral estate. It does not speak in terms of ownership of property. The United States has proposed that the powers were transferred from AUC to UDC by virtue of the provisions of Section 13 of the Termination Act. Section 13, by contrast, speaks only and speaks exclusively of powers with respect to the ownership of property. The authorized representative powers were not powers that had any relationship to the ownership of property, and in particular to the ownership of property by the individual mixed blood or terminated Ute Indian, which is all that Section 13 relates to. The individual petitioners in these proceedings are members of the affiliated Ute citizens who have brought a fraud claim based on their sale of stock in the Youth Distribution Corporation. Now, for the purpose of their fraud claim, this distinction must be kept in mind. The question of the regularity of the formation of the Youth Distribution Corporation is not an issue. It is not an issue because the proceeds from the management of this joint mineral estate over the period of time that we're here concerned with has been paid in the form of dividends through the Youth Distribution Corporation. The recognition at this point that the affiliated youth citizens as the proper authorized representative will not have the effect of restoring to the terminated youth the dividends or the royalties which they have lost by reason of those practices. Thus, the regularity of the Youth Distribution Corporation is an issue with respect to the affiliated youth part of the claim. It is not an issue with respect to the individual Indians' fraud claims and the RIA side of this case. The defendants in the fraud claims are the First Security Bank of Utah and two of its officers. The United States is not a defendant in the fraud claims. The conduct of the bank and its officers arises by reason of its conduct in executing its duties under a business agent agreement, which contemplated that they were to act as stock transfer agent, to keep the books and records of the corporation, and perform certain incidental services. It is the common elements of the conduct of the bank pursuant to that practice which are important as far as the fraud claims are concerned. These common elements affected every Indian sale. It doesn't really matter who the sale was negotiated with. The common elements necessarily affected every sale. By common elements, I refer to the fact that every Indian stock certificate, which had bold red letter legends warning him of its value and of restrictions on its transfer, were locked up in the bank's vaults, and the bank refused to make those certificates available to any Indian prior to August 27, 1964, even when he requested them, and made no alternate effort to convey the purport of those warnings to the Indians who desired to sell his stock. That practice affected every Indian. The bank and its officers were also acting in a capacity which we could loosely refer to as a market-making function. That is, they were encouraging purchasers of the stocks, many of whom were located throughout the United States. They were encouraging the sale of stock, and in many cases they were doing these things through the medium of agents on both sides. That practice affected every Indian sale, notwithstanding who he may have sold to. In every Indian's sale, there was also a deviation from the regulatory provisions which had been promulgated by the Secretary of the Interior. Specifically, the regulations required that any sale must be by endorsement of the certificate itself. Never in the history of the Youth Termination Acts, at least prior to August 27, 1964, was a sale negotiated in that fashion. The regulations also required that the superintendent of the reservation supervise the price and the terms of the sale according to the terms of the offer, which required payments by cashier's check, certified check, or postal money order. Never was a sale supervised in that fashion. Those practices affected every Indian's transaction. Also, the bank and its officers neglected or failed to disclose to any of these Indians that they were acting in its dual capacity as market makers in relation to this stock. Now, it is true that there are also a large number of other facts which affected any particular Indian stock, and the petitioners certainly take the position that those dissimilar facts, standing alone, would be sufficient to give rise to a fraud claim. And the bank, in its briefs, in this case, has attempted to focus on those dissimilar facts. The petitioners take the position that it is not necessary to get involved in the dispute over whether any particular Indian got a car, whether economic pressures were applied to any particular Indian, and if so, in what fashion the economic pressures were applied, for the simple reason that the common elements which necessarily affected every transaction are sufficient to give rise to the fraud claim, and were so determined by the trial judge. The claim against the United States with respect to the sales of the Youth Distribution Corporation stock is bottomed on negligence. It is a claim of the petitioners that the United States negligently permitted a deviation from the regulations which had been promulgated, permitted a deviation from the requirement that the endorsement of the stock certificate be the only way in which this stock could be transferred, substituted in its stead the transfer of the stock by means of a separate stock power. That may seem unimportant on the surface, but the effect of that deviation from the regulations was to withhold from the Indians the warnings which were printed on that stock for his benefit. The United States also, even though as we read the statute and regulations, Congress plainly directed that the superintendent was to regulate the price and terms of sale, instead of doing so, the superintendent adopted a practice of receiving a certificate from the Indian himself, the selling Indian, who was legally in the position of a ward, that he had in fact received his money. Thus, there was a complete abdication of the responsibilities of the United States in that regard. And the person who was legally in the position of the ward was the one who the United States looked to satisfy those regulatory obligations, whereas Congress, I think a fair reading of the Act would bear me out on this, plainly contemplated that the TIH should
David Stewart, that statute itself, was that getting rid of the wardship stating?
That is true, Mr. Justice Marshall. That was the dominant purpose of the statute. But it's also true that Congress recognized in adopting this statute, as it did in all of the Termination Acts, that these people were going to have some trouble. They were not accustomed to managing property because they had been under the protective wing of the United States for so many years. And so Congress wisely, I think, directed that there be a phased period in which services and protections would be withdrawn from them, and that period was to extend for a full 10 years. Now, experience has proven that even that wasn't enough, that these people needed protections even beyond what Congress contemplated. The thing we're here complaining about is that the protections which Congress directed were not secure to these people, and that by reason of that, they were deprived of their property. Now, in many ways, the complaint of these petitioners seems based upon fine distinctions in the law. We presented an awful lot of complex legal arguments in the briefs. In reality, however, we're talking about a very fundamental proposition, a very practical and fundamental proposition. We could analogize, I think, to a situation where, say, a person were to buy an annuity and pay for it throughout his life. And when that annuity were to mature, instead of the insurance company paying the proceeds of the annuity to the annuitant, simply took the proceeds and invested it for his benefit, we'll say, in a mutual fund. Now, it is not a question of whether that investment is a good one or a bad one. It's not a question in this case as to whether the Youth Distribution Corporation is a good idea or a bad idea. It's not a question of whether Youth Distribution Corporation was well managed or whether it was mismanaged. The problem really is the indignity of the act itself. To take a group of people, such as these terminated youths, and say to them, by way of congressional enactments, that we're going to remove restrictions on your person and on your property, and you're going to be treated like any other citizen in this country. And yet, before that property ever gets into that Indian's hands, to take it and assign it, to have BIA assign it to this corporation, and not only to assign it, but to make the assignment or purport to make the assignment irrevocable, so that it would bind himself and his heirs forever. Now, Congress plainly declared in the statute that they were to receive their property in such a fashion that it's to be inherited and bequeathed. That is the language of the statutes. But BIA attempted to completely frustrate that this congressional intent by making this assignment to the Youth Distribution Corporation. Now, turning to the Rule 10b-5 aspects of this case, this case represents the first time in which this court has had occasion to state, with reference to the fundamental ingredients of a cause of action under Rule 10b-5. I submit that the case is a very good one. It's a very good vehicle for this court to consider the elements of a fraud action under Rule 10b-5 because of the wide variety of misconduct which is alleged in this case, which afford this court an opportunity to consider the whole array of possible conduct which could be considered as a violation of Rule 10b-5. It's also a good vehicle because the petitioners themselves have a peculiar need for the sort of protections which are afforded under Rule 10b-5. And this court, many times in the past, the capital gains case, on the other cases which it has considered on related issues, has said that the need for investor protection is a relevant consideration which should be taken into account in determining whether any particular fact situation falls within the proscriptions of Rule 10b-5. Because the individual's forum was claiming to respond based for action, not for the Rule 10b-5 claim, not for the fraud claim. The federal courts are vested with the person jurisdiction under the exchange law, or the side of action that it was done with some. So that's with alleged conduct. Is that the fake people on the other side in the state court speaker? There is no other claim standard, so they could go to. I don't think that, well, I suppose it would have been possible for them to bring an action under the state of child law on the fraud claim. I think that it would have been impossible to bring an Indian law claims under the state court. Even with respect to the state of child law, however, the very reason that most of these security fraud cases wind up in the federal court is because the remedy under the state of child law is inadequate. It's inadequate for a number of reasons. First of all, the states are plagued with short statutes of limitations, with frequently bar fraud claimants. Secondly, the state procedure affords the opportunity for devices such as non-resident stock bonds and things of this sort, which are employed by defense attorneys to discourage grant of Elizabeth Flynn. And so, in general, as a practical matter, he suggests that Indian claim that fact alone may be abroad or be put up. No, I don't suggest that. Now, as I read Rule 75, this basically requires, in addition to the jurisdictional element, the showing of true element. And they are as follows. First of all, there must be one of the prohibited acts. That is, there must either be a receipt for gain, or there must be a misstatement of a material fact for omission to create a material fact, or a course of business which, if pursued, might result in a fraud. Secondly, that conduct, whatever it might be, must be accomplished in connection with the purchase or sale of a security. Now, I stress the words in connection with, because, as Professor Bromberg has said in his treatise on the subject of Rule 75, the words in connection with are the loosest, and we must assume ineffectually the loosest linkage, which is described in any of the federal security laws. Section 17A of the 1933 Security Act, for example, uses the term the fraudulent practice, which is substantially the same, must be in the offer or sale of a security. It must be in the offer or sale. This act said in connection with the offer or sale of a security. The lower federal courts, during the period of time that implied liabilities have been developing under the Exchange Act, Section 10 and Rule 10b-5, have wrestled with the question of whether additional elements may be engrafted onto those prescribed by the rule. They have considered a wide assortment of additional elements, including scienter, proximate cause, reliance, I think are the principal ones with safe and fitting. The error of the court below in this case was that it went far beyond even what has been required in other courts which have considered these elements, and required in this case that there be a direct participation as a purchaser or seller, and that direct participation must be for a crime. Thus, the lower court in this case imposed upon each plaintiff a standard which is far higher than even that which is prescribed in Section 17A of the 1930 State Security Act, and I might add, even higher than was required of common law. Which note that the limiting factors which are prescribed in the statute and rule itself are entirely adequate and are the only ones which ought to be considered. I refer in particular to the requirement of a showing of materiality. The respondent bank itself has noted that even the courts which talk in terms of reliance quite often come up defining reliance so that it comes out sounding just about like materiality. The other limiting factor, which is prescribed by the statute and rule, is that of causation. I note that the rule itself does not use the term causation, but I cited some legislative history in my brief which indicates that Congress, in considering the 1934 Act, did make reference to the fact that any person who was injured by these practices, or whose injury was caused by these practices, ought to be able to recover, and therefore I could not take the causation in the but-for term, would these an appropriate limiting factor. I think as I constructed and bore out by the language of the Act, and I note in particular within this Act, Congress attempted to proscribe heavy misconduct as a type which is defined by the rule in connection with pennies, purchase or sale of goods. I think the use of the term penny in both of those contexts was a calculated one, and but it should be given a thought. As I say, the common law, in a case of cost analogous to the fact now as far, does not impose a requirement nearly as high as that required by the Court of Appeals in this case. I cited in my brief in common law the chief cases which were which arose in the context of market security. And what those cases stand for, also some writing with Professor Thompson, I know this the expert on corporation. What those cases stand for is the proposition that if a person makes a misstatement, we'll say by means of the prospectus, and he would say the strictest to the public at large. In one case, that they tried it by means of leaving it at a bank, so that any member of the public could pick it up and read it. If there are lies in that prospectus, any member of the public should be permitted to discover it, because it was directed to any member of the public. Thus, they come within the ambit of responsibility. By contrast, if the misrepresentation is made through a limited group, why then also the ambit of responsibility would be further restricted. That was the rule of the common law, and it is universally recognized that Rule 10b-5 as an expansion of the common law, and therefore I suggest that you should at least read this rule as broadly as the Canadian common law. Now, as I say, the facts of this case and the legal questions are complex. I would like to reserve an ample amount of time for rebuttal, because I think that I will have a lot of things that I will want to respond to in relation to the government in particular. As there are no questions by the court at this point, I'll reserve the balance of my final for rebuttal. Am I correct? Is including the just Christmas from not the district court levels, in month for the station was $1,600, so it's extra. If there is the evidence in the record, the supporting most of it. I think there's no question, Mr. Justice Blackman. I think we have to understand what Judge Christensen did. Judge Christensen considers all of the evidence which was presented, including in particular the evidence of the appraisal of the mineral estate, which, if divided by the number of shares involved here, would have, and capitalized, would have given rise to a damage figure in excess of $28,000 per share. Judge Christensen felt that would not be a proper result. He caused just a position of those shareholders who would not go. And I tried to his comments in the Sunday Square. He linked records to this, that it would seem unfair to in effect penalize those who did not sell by giving those left prudence who did sell the full value immediately, whereas the others may have to wait for decades, maybe close to recover that amount. Now, I think that was a wise approach. The trouble with it is that it leaves the benefits, the remaining value that mineral estate in the hands of the wrongdoer. And that was the very reason why the accelerated use case was initiated. And it was initiated, I must say, prior to the time of judgment, so that there would be a way that windfalls to the fraudulent parties could be avoided, and the mineral estate could be vested in those and the remaining mineral estate could be vested in those properly entitled to. And then I understand it all of that way. You're not entitled to just a resolve. I think that if the court was to grant the remedy such as I had suggested, we would have to remand this case for a further hearing on what the proper amount of damage we should be. We'd have to have some evidence on what the distributions were during the period of time that the settlement used to not be significant on so jail to the North State. Well, is that for public? That's state court. These two consolidated cases raise quite different issues with respect to liability in the United States. The issue in the affiliated use case is whether the district court properly dismissed the action for lack of jurisdiction, finding that it was an unconsented suit against the United States. The issue in the Rayoff case, on the other hand, is whether the Court of Appeal properly found the United States had no duty to prevent terminators mixed blood Indians from selling their shares at less than fair market value. Although the cases raise quite different issues, both as counsel for the particular case said, both relate to the Youth Partition Act of 1954, and I think that this is that act and the working of that act is necessary for an understanding of the claims in the case. In 1954, the Ute Indian tribe, Winslow and Ouray Reservation in Utah, consisted of approximately 1,800 members. There were two distinct groups, the full-blood Indians and the mixed-blood Indians. The mixed-blood Ute Indians consisted of approximately one-quarter of the 1,800 members of the tribe. For a number of years preceding 1954, there had been considerable friction among the mixed-blood and full-blood Indians. The reason for this was quite understandable. Many of the mixed-bloods did not live on the reservation. Many of the mixed-bloods were already integrated within the non-Indian societies. Their standard of living was virtually indistinguishable from the non-Indian society in which they lived. Their educational status was the same. Friction between these two groups reached its peak in 1950 and 1951, when this group of Indians on the Uinta and Ouray Reservation became entitled to 50% of the $31 million judgment against the United States. Full-blood Indians, also quite understandably, wished to use this money to improve their reservation to build schools and hospitals. However, many of the mixed-bloods wished to have the money in cash, had no interest in sending it on a reservation where, of course, they never lived. It had not lived. The groups met in tribal council over a period of approximately 1 year to work out these differences. The Ute Partition Act of 1954 is a result of their compromise. It represents, more than anything else, a treaty of peace to punish these groups, because the act itself was drafted and hammered out by the Indians and then introduced at their request in Congress. And while the act was being considered by Congress, both representatives of the mixed-blood and full-blood group went to Washington and fully supported the bill, and said that it had been submitted to a vote of their respective memberships and approved overwhelmingly. There are three main features in the Ute Partition Act. One is the division of the tribal assets that, of course, did not affect the individual assets held by the individual members of the tribe, only the tribal assets. The second feature is the determination of the mixed-blood Indians, who were defined as having not more than one-half Ute Indian blood. The third feature is that the full-blood the trustee relationship between the United States and the full-blood would remain. The way the act was administered and the way this partition took place, of course, was quite complicated. The one thing that can be said about it is it was done by the groups themselves. That the act provided that the groups would, first the mixed-blood and full-blood groups would agree together and devise this plan for dividing their assets between them on the basis of the relative numbers in the groups. This turned out to be, when the final rolls were published, 27% mixed-blood and 73% full-blood. The next step in the process was to have the mixed-blood meet by themselves and determine the plans for distributing these assets. Plan of distribution and the plan of division are contained in the record in this case. One of the difficulties, of course, the group ran into was how to distribute the assets that were not easily, equitably divided, such as oil, gas, and mineral rights. When the Ute Indians were considering drafting this act, they of course realized that it would be inequitable to split up solely on the basis of geographic consideration the mineral rights. The tribe owns that time approximately 1 million acres of mineral rights, which is approximately the size as Delaware. So what they did and what they decided to do was to retain the mineral rights, oil, gas, and mineral rights, as tribal property, and to split up only one thing, or only two things: the proceeds from the mineral rights and the management. The management was to be joint, the proceeds were to be distributed on a 27% to 73% basis. As plans worked out, of course, both groups needed representatives to negotiate the plans and work them out. The tribe had its own tribal council, and that was no problem. However, the mixed-blood, first of all, adopted a constitution and formed an organization known as Affiliated Ute Citizens. In the Constitution of the Affiliated Ute Citizens, it provided the delegating authority irrevocably to corporations in order to manage certain of the assets of the mixed-blood group. Three corporations were formed: the Rock Creek Cattle Company, the Antelope Steep Range Company, which dealt with grazing land, and the other Means Distribution Corporation, which was involved in its code. The corporation was formed in 1968. It issued 10 shares of stock to each individual mixed-blood Indian, and the mixed-blood totaled 490 at that time. This then is the posture of the case. You have the they specifically authorized this as a flip. The
resolution that divided the North, but the LA,
Yeah, they adopted a resolution. There were two actions, actually. The first thing they had is a general membership meeting, and it was a quorum under their constitution. What was it? How many people should require a quorum? Mr. Friend, 30. 30.
I'm trying to forum, I'm trying to
Yeah. How many attended the meeting? I don't know. It's not today. The issue in the affiliated, I will talk first about the affiliated youth space and understand the issue with that.
get all the kids everything together at or group.
So there were two acts. After the first thing was when they divided the plan of his distribution. The plan of distribution had the isolated section 10, the considered an appendix to the native fruit by the tribe, considered in full. They contemplated forming a corporation. That plan to handle the mineral rights. That plan was unanimously adopted by the members, or at least so it's reported in an ethics or in a resolution by affiliated youth citizens. The next step in the process was the actual delegation of the authority according to the Constitution, and that was the second resolution I was talking to with even Mr. Poyos at a moment ago. So I'll first to the issue in the affiliated youth case, and then discuss the issue in Rayok. In the affiliated youth case, the suit was brought by the unincorporated association purporting to represent all disseminated missplit Indians. So, with the lending responsibility and review of Indian affairs, the proof of right, they were supervised throughout until 1961 when termination took place. Yep, of course, there was constant consultation. And I might add, there was a contract with the University of Utah, which provided for educational services, training, relocation, and other factors. Well, I was thinking in particular there wasn't particularly been described as far as by which the discrimination. Yet there are the misdivides were simply effective. Yes, land invasion of the corporation in the schools and the medicine. The plan was worked out by the office project. But the plan that I taken was and all that is going to do is on bench like trial. Well, it was rather an informal arrangement. What they tried is the mixed bloods determined their own plans for distribution, and with the full bloods, the acts provided that the act survived with it matter of right for. Yeah, the act provided for the plan of distribution and the plan of division of the tribal acts that they provided for formation of the affiliated utility. Yeah, oh yeah, that's correct. 677 is the act provided. In the affiliated youth citizen case, it was brought against the United States in name and form, and in the claim was that the individual members of this organization were entitled to, quote, an individual undivided prorated share of 27% of approximately 1,200,000 acres of mineral land, subject only to the right of the association to manage that property jointly with the Tribal Business Council. Jurisdiction was invoked primarily under 25 U.S.C. Section 245. The district court dismissed the lack of jurisdiction and for failure to state a claim upon which the week to be granted. The Court of Appeals affirmed on the basis that this was an unconsented conclusion against the United States, and that Section 345 did not supply the necessary consent to these suits. Unlike many recent cases in this court where the question was whether a suit against an officer of the United States was really a suit against the United States, this case, there's no such question. It's brought directly against the United States in name and form, and it's long been held in this court that a suit relating to government property against the United States cannot be brought without the United States consent. This principle applies equally to Indian land held in trust by the United States and applies also when the suit is brought by a group of Indians claiming the beneficial interest in that land. In this case, there's no dispute whatsoever that the United States holds title in trust to the mineral assets on the reservation. Therefore, plaintiff's action in order to go forward has to be based on some specific statute, federal statute, authorizing this kind of suit. They've invoked Section 25 U.S.C. 345. That section, which is set out on pages 90 to 91 of our briefs, provides that any person who are whole or in part of Indian blood or descent who are entitled to an allotment of land under an act of Congress or claim to be so entitled or under any allotment act or under any grant made by Congress, or who claim to be unlawfully denied or excluded from any allotment or any parts of land, can bring an action in the district court to determine, in the jurisdictional section is after the semicolon, where the district court may determine any action exceeding proceeding involving the right of any person to an allotment of land. We think this case does not fall within that statute. Our affiliate Litse that was built to play the extent for as co-rating. Yeah, they asked for yes, I'm not exactly sure how this should be done, but I quote, they claim to be entitled to an individual undivided prorated share of 27% of approximately 1,200,000 acres of mineral. The merits of that question have never been reached. Allotment is a term of art in Indian law. In the latter half of the 19th century, it was the policy of the United States, particularly expressed in the General Allotment Act of 1887, shift the rights of Indians in real property from simply participation in tribal properties to rights of individual ownership in particular tracts. The land or the mineral estate involved in this case is the very antithesis of an allotment of land, because it's never been divided. It's tribal property, there's no question about that. There's no individual ownership of this land involved. In the usual allotment situation, a reservation would be surveyed, a tract of a certain number of acres set aside, the Indian would make up selections, and the Secretary of Interior would issue a patent. Section 345 relates only to those kinds of situations. He thinks this is not a suit regarding an allotment of land by any stretch of the imagination. Turning now to the Rayos case. In Rayos, there were 12 designated mixed-blood plaintiffs who claimed that during 1963 to 1954 lockdown, yes, we pointed that out in our brief episode, that it was stipulated, I might point out, in the Rayos case, that the corporation was a validly formed corporation, the district court so found. The whole point of the Rayos case was that the stock had substantial value. In the affiliated U case, on the other hand, the claim was the corporation was invalid and that it should never have been given the assets to manage to begin with. We think they're basically innocent. If they're right in that convention, then the stock wouldn't have any value. That's right. In Rayos, the 12 designated mixed-blood plaintiffs sold their stock during 1963, 1964, and 1955. It sued the United States under the Federal Tort Claims Act, and their claim was the government was negligent by selling to prevent them from selling their own shares for less than fair market value. We think the Court of Appeals correctly held this trust relationship between the government and each individual in this blood terminated in 1961 before any of the sales took place, and that the government therefore had no duty to supervise mixed blood sellers disposing of their stock. As I pointed out, under the Act, the oil, gas, and minerals were owned by the tribe and were not divided. But the proceeds were, and the management rights were divided. The mixed bloods formed UDC in 1958 may issue stock. Under 677Z of the Act, the Secretary of Interior on August 27, 1961, and this is on page 40 of our brief, issued a termination proclamation stating that with respect to each and every individual mixed blood, federal restrictions on the property have been removed. Federal trust relationship with such individual terminated. If such individual shall not be entitled to any of the services performed for Indians because of their status as an Indian, and all statutes of the United States affecting Indians because of their status as Indian shall no longer be applicable. We think that after this period, Secretary of Interior had no duty to say, or had indeed no right to say to an Indian, you can't sell your stock for that amount. Or that I will only let you sell your stock if you really need the money at this time. Or even, as he might have said if this were restricted Indian property, you can only sell your stock if you send the money and the proceeds goes for food and clothing for you and your family. We think that after 1961, he not only had no duty to do that, I think the mixed bloods would have been infuriated if he had tried to do that. The plaintiffs have claimed, however, that there was a right of first refusal, and that they claimed this right of first refusal somehow created this duty on the part of the United States, and particularly the serving and supervising their shares even after 1961. So they part to the right of first. not entirely clear, Mr. Justice Brennan. We think the right of first refusal stems from Article 8 of the Articles of Incorporation as Use Distribution Corporation, which provides that any mixed blood dissolve his shares before August 27, 1964, and must first offer them to members of the tribes. There's no acceptance of that offer. He may then sell at the same or greater amount under the same terms and conditions it offers to the members. The Secretary of Interior was required under the Articles of Incorporation to certify to one saying that the offer to members of the tribes was made in accordance with the law and regulations of the Secretary of Interior. That is, the original offer, which, if not accepted, would allow the mixed blood to sell to whomever he pleased. It's contained on page 6 for the exhibit appended. Also, the regulation, finally, I might point out, that under the Act, and 677N of the Act, was a similar right of first refusal for land. And so when the Secretary promulgated regulations dealing with the right of first refusal for land, the very last clause in those regulations stated that as far as practicable, these regulations should apply to sales stock in the corporations formed by the mixed blood. The bank operated as transfer agents of the stock, and the Youth Distribution Corporation and the bank worked out a procedure in September of 1963. I might point out at this point, there were no sales of stock until the late summer of 1963. At the time the corporation was formed until the summer of 63, there were no sales of stock. The first sale took place, I think, actually August of 1963. The bank worked out a
Just for a long time on the right of first refusal. Looking at the summary of your argument on page 23 of the brief, but for a mixed blood to sell its stock to a non-member of the Ute Indian tribe, the required first to offer the stock to members of the tribe at a price not less than that of which he intended to sell to the outsider.
Yes.
Doesn't that be not more?
Yeah,
Not more, at least.
that's correct.
To not sell it to an outsider for less.
That's correct.
So may I take the liberty of changing that?
Yes, you tweaked it. It's very sorry about sir. In any event, the bank operated a transfer agent stock, and they worked out a procedure with the Youth Distribution Corporation, whereby, this is contained on page 29 and 31 as the exhibit appendix, whereby, after the offer has been made and not taken up by a member of the tribe, the seller, when he completed his sale, would furnish an affidavit and a stock tower to the superintendent of the reservation. And then the superintendent of the reservation would issue this certificate stating that the original offer had been properly made to the bank, who would then transfer the stock to the buyer. Apparently, the main thing, according to Simpsons, that the superintendent did wrong here was that he failed to investigate whether the plaintiffs in this case was telling the truth in their affidavit. The superintendent apparently thought that the regulations in the Youth Distribution Articles of Incorporation required him only to certify this original offer was proper. And I think maybe that was too strict an interpretation of the regulations. However, the one thing that seems perfectly clear is that the right of first refusal did not create any duties to the people that were selling the stock and who apparently had not told the truth on their affidavit. Because the right of first refusal, if anything, was for the benefit of the people who could buy. It was for the benefit of the people that remained in the tribe, and also for the mixed blood, so they could retain control of their corporation. Sellers obviously cannot accept his own offer. We think, therefore, it created no duty for these people who were bringing this to the mixed blood sellers who claimed to have skulls for leftist fair market value. We don't think they're entirely without protecting, however. I think, and point three is part 3 of our brief deals with that question, whether they entitled to protection or to expanding. The first time? Just that let's do trust me. I represent the products of the bank and the two individuals who are employed by the bank, Scale and Haslam. Court should desire that this court stone and decision of the United States Church and Court of Appeal. One difficulty in this case was the general very there. That counsel to the plaintiff now the authority can exchange commission in connection with its brief has instructed hypothetically, but it do not relate to the particular individual who is a petitioner in that case. As the suggestion is made here for Joey thing to do that somehow we polluted the atmosphere with some kind of fraudulent effluvium, which was breathed by everyone who had this stock to sell by all of the mixed blood. And the question, of course, is whether or not Yale and Vaseline, our employees, violated NB Law. And the only way whether that can be ascertained is whether or not that asbestos, whether it caused damage to any of these 12 deficiencies, is to be found in the fact the law related to those 12 individuals, which is not to be found out here in abstract. Plaintiff counsel of the petitioner's counsel has just a man repeatedly tailored as coat of many odious colors, never been worn by, and which does not fit any of the particular prescriptions in this law. So I can only appeal to the court in deciding the cases can only be determined whether or not these 12 individuals have been injured or any of them have been caused damage, such as a violation can be filed by examining the facts and the law with respect to each one of the offenders individually. Now let's go to the acts which have been considered or which may have been considered violating the Kennedy Clause. Today, with respect to the wrongful acts of the facts or the corporate stuff, my friend and colleague, Mr. Houston, has said that they retained the stock certificates and facts so the Indians couldn't read, the next one couldn't read the notation on it that says that we value for him. Well, of course, that was done by the banks at the request of all the youth distribution corporations at the request of the Bureau of Indian Affairs, reading of all three, believing that would be helpful to the Indians so they would lose their shares of stock. That is hardly fraud, and hardly is part of this pollution of fraud which fills you out. As far as the market making is concerned, which is a mention, the Turkey Court of Appeal specifically said there was no evidence that Sebastian did anything about making market. And on the general matter, it is a real help to this court of Mr. Nielsen, and I just stand up here and he said he gets, and I pleaded cities. All he and I can do is refer you to the record, and that is what I do. I just categorically deny that there was all these actions by the government that's created an atmosphere of fraud. But let's talk about specific things. But even the Circuit Court of Appeal said that they did pose a possibility of violations can be filed in connection with the action of a couple of the put. I think we ought to examine those. And I'm willing to examine those where the first is said maybe you good, German good pilot. Section can be found. Let's take Mr. Gale. It would be kept in mind, first of all, that of these 12 petitioners, Mr. Gale bought stock from Allers too. She bought 5 shares from Mr. Reed, 5 shares from Mr. Watchuk, and that's all he bought. With respect to the other 10, he didn't buy any shares from them. He had nothing to do with encouraging the sale, with participation in the sale, of getting any benefits from the store. Nothing at all to do with them, except in connection with some of them. He signed an notarized an affidavit, or he guaranteed his signature on stock for us. And that's all they had to do with it. And some of them he had nothing to do with at all, didn't even know about. There's that Mr. Hardman, on the other hand. He bought some movie sewer. One of them was, again, Mr. Reed. He bought his other side share. Because he bought it. John Reed. That's principle. Good. But none of these were bought to the tank. They sold to the banks. They ain't done nothing on. He bought it. I don't know. He used car dealers. These car dealers got in the picture on their own. And there were many used car dealers in on the picture. Of the approximately 1,300 shares of stock sold in this very 64 and 54 and 55 of the point, the work was even with the 1,300 shares of stock sold. There were 32 different white names who purchased stock. Matter of fact, Galen Haslam bought 115 shares, between together. And I waiting a third percent of all those who were bought sold. Well, some of these were used car dealers. Now, the evidence doesn't show whether these car dealers themselves committed fraud on these people. He virtually made with that. The record doesn't show because these car dealers paid some money and ran, got out of the state, settled out of the state. So we cannot say, but it may well be. Some of these car people just like the body, some of these two bosses. But some of the thoughts and gives him less than desirable as to the rate.
There were still was 113 individual non-Indian buyers of this stock. You had all of the trade involved.
We all know there were 32 non-Indian buyers that I know of. There were 113 pairs of stocks, bauxite deals, also of kinds. Out of 1,300 shares that were sold by the mixed fund.
There was a total of 32 buyers.
Right.
God knew that.
That's quite some.
Now, the buyers were not all people from this locality, but it was some of them from elsewhere,
Yes, I think the record shows there were about 7 of them who were outside of this.
How far away is it?
One's from Illinois, one's from New Orleans, one's from Arizona, a couple from Colorado. And
How was people that far away likely to know about the availability of their
I don't know. They may have known relatives. Or there was he besides advertised it. I don't know how the infrequents found out. I know that some of the CNN and they composted it. I can take the fact that the task for 8.
Quite allegations that the bank and its employees just made a market.
Yeah. Now, Tam Lee said that is utterly false. The rest of the United States but just says that specifically if they but they did not support the sanction that the bank was a monster make.
Is there any showing of how somebody's still dollar with all about the availability the Charlotte and stuff to stay out in the little Valley Queen, little town of Yukon?
I don't know how the man in Illinois knew about it. It's maybe in the rest of his honor, but I don't know. Now, because he could have appealed Shreds a deal in connection with scales, but 5/3 thought that has to roost. I'm asking this because I think this is my most dangerous state that he's violating the shit. Yes, I can blame boss 5 years in January. Circuits which just he made is very thankful saying his representation was and perhaps are non-disclosed. He bought this shares for $350 and sold them sometime later to another black man for $530. The same shares. I was the church details and I driven a lot for with the circle box. It said, there is the fact saying misrepresentation here because the indicators of this man reads is for $350 was the market value of the stock at that time when it wasn't, thus it's on sale up to 5/3. He might be guilty of a non-disclosure because he did not reveal to Mr. Reed that he was going to sell it later for $530. Now this is the worst case. Then the circuit said, however, there is no evidence, even if this is a misrepresentation and a non-disclosure which was being violation can be filed. There is no evidence that there was reliance there. That this was the cause, this misrepresentation, or this non-disclosure was the cause of sale. Now, that I'll go on with that because I want to put Haslam in focus here too, because they're talking that he did, the circuit said might also is in a violation. They said that if Haslam indicated when he purchased his stock, that was the market price, he made a misrepresentation. However, with Haslam, there is no evidence directed that he ever sold it to anybody else at any price. So it cannot be found to be a violation of 75 as far as sheep. But now we're going back to Mr. Gay. Question we get down to the real question that is raised by a very response director. And that is this subject of reliance. Now I think we all get down to chewing on the bone as it's a real bone of conception in this matter. What is the story going to say about reliance? Is reliant to be assumed if the representation or the non-disclosure is material. Now, the reason about that I did is because in the case of Mills versus Autolite, the case of this decided by this court last year, and if the case which deserves attention on this subject, the case which I believe is right, with which I do not quarrel at all. It's just that facts entirely different. So in that case and this, in the Autolite case, you will recall the matter of minor stockholders suing as a class to set aside a merger on the grounds that a statement in a proxy program was failed as disclosed. That those of the selling of the merging corporation, the directors of the merging corporation sent out the proxy, was completely controlled by the corporation into which it was to be merged. So the lower courts could have not. Well, and as a matter of fact, there were thousands, according to Justice Harlan Attila, there were thousands of stockholders involved, and these minority stockholders. And the problem was in this trial in the circuit court, how are we going to determine whether or not they relied on the non-disclosure or they were influenced by the non-disclosure in the proxy statement? Whether or not they would have voted otherwise, had this fact been included in that scope. In the circuit court, the trial came up with a rather fictitious formula, saying, well, this is the tough thing to do because there are thousands and we can't inquire into the reliance of each one, causation of each one. So we'll adopt this formula. If it appears from the evidence that the merger was a good move, then we can assume that if they had known all the facts, they would have voted. Well, this court, and I think quite properly, said that doesn't prove anything, and we're not going to accept that formula. And this court said, and these I think are Justice Harlan words almost exactly, quoting the circuit court. He said that the reliance of Saudi can scarcely be inquired with. So this court decided that in a case like that, where the non-disclosure was something that everybody knew what it was, where it was certainly material, or the courts that Justice Harlan said had a propensity to cause someone to vote one way or another. Then we're going to assume that there was reliance, that there was causation. The causation and the reliance and materiality were merged. And I think that was proper in that case. That these people could not have been suspected any other way when there are thousands of them, you can't put them on the stand. This is an entirely different case. In this case, there were 12 petitioners. Every one of them took the stand. And all a lawyer had to do to Mr. Reed was say, would you have sold your stock if you'd been given this information? And he could have said yes or no. Every one of them could have been asked, in effect, if they relied or if they didn't rely. If this caused them to sell. But that evidence was never in the record, never put in the record. Perhaps the district counsel didn't know what they were going to say, or they were going to say the wrong thing, or forgot to ask. We don't know. The fact is, it could easily be in the record. And I don't think the court wants to take the position for posterity that when you can determine whether there's reliance or causation without any doubt, that in those cases we should assume it, and we don't have to. I think that would be dangerous jurisprudence.
What he does is turning reference in here to the fact that plaintiffs for Bellwether plaintiff.
Yeah.
Was it class action or was this just
It started as a class action, Mr. Justice, and then Judge Ritter decided it's not a class action on the ground that the individual problems are more expensive than the common problems. And so then in conference counsel with Judge Crippen, it was decided that we should take 12 cases, and it's just the Christians who just told them Bellwether cases. We should try those, and then all of the information that was reduced, the evidence that was supposed that would be common and usable in the other cases, could be used in the other cases they ever did try. And we go ahead with these 12, have it tried, and the start.
So these are 12 separate plaintiffs.
Right.
This was and the district court decided it was not a proper class action.
Right.
but they did have good many combinations.
There are some combinations. That is true. Incidentally, the 12 were chosen this way. 6 were chosen by the plaintiff, and 6 were chosen by the defendants. And that's the way the 12 were chosen.
I just never heard the bellwether case is somewhere between an individual case and class action.
Yes. Fair enough. I think Twilight Zone. Now, first, what we relied on is the List versus the Fashion Park case. And where it says there needs to be reliance, and they just describe reliance. In that case, they have a case of a representation. The court on the Fashion List versus Fashion Park, Second Circuit says the proper test is whether the plaintiff would have been influenced to act differently than he did act if the defendant had disclosed to him the undisclosed fact. Now, that's in the case of a non-disclosure. In the case of a disclosure or a false representation, the court said, insofar as is pertinent here, the test of reliance is whether the misrepresentation is a substantial factor in determining the course of the conduct which results in the recipient's loss. Of course, this was the case, Fashion Park, where there was an individual involved who could be put on the stand and it would be questioned as to whether he relied or he didn't rely. It's a case again where he sold his stock for $18.50 a share, and the corporation shortly later, the company sold all the other stocks for $50. Then he sued. The court said, well, there isn't evidence to show the non-disclosure that they were going to sell. There is no evidence that they were going to sell this because that had an effect upon your sale. You may have done it anywhere. Now it closed by just what is the first skill describe how it affects the liability of the bad. Yet in this case, Your Honor, they decided that there was no evidence of rely or the bank, the bank and as far as the two individuals that each other. Since there was no reliance, there was no liability. But they said, we will send it back for actually breaking in accordance with this opinion. Now, if the court wants to ask me what I think that means, I'm not sure I could give an accurate answer, but I think it means to give somebody that they could prove it honest. I think that his means or gave an opportunity was those who were involved in the state to Gale and test to prove their cases and to prove their life. I don't think it means for these 12 to go through a conduct of bodily integration. That's why I made the chances. Right. In the ones that I've mentioned, these cases, yes. 2 cases, how's the bear? They said the bank would be responsible for it. So they did. They attributed their guilt to the bank because the conduct described right there, she thought, I still lie, so we did lie. Right. Which right, Your Honor, out of the remit. Yes, Your Honor. And the major damage. Yes, they said what they thought the major damage should be. They said the cases to be considered, those cases where the mixed lot sold to Gale or to Haslam, and the measure of damages is how much the difference between what they sold to Gale and how much Gale got from somebody else. No. I do, you're accustomed to things such as the law about the concepts involved, but not to get the risk to have people. That's right, John. We're willing to accept the challenge of the circuit courts to go back and let them see if there was reliance. See that the concepts by the bank, but perhaps like individuals, is the type of conduct that's by reckon. I concede in the one case that I mentioned, John, the purchase from Mr. Gale, by Mr. Gale from Mr. Reed. In that one case, I concede if you accept the facts as the circuit saw them, and I will do that for this purpose. In the one case only, if there's none of them, if an individual comes in and wants to sell it, the bank, to employ the bank's going to buy it and stuff, discuss the cut. It's not a reseller. He just flaps, it's a tempted. If he is going to, he knows that that's on that he's going to sell it to somebody else for some more money.
There's another stuff that want to tell it stuff to somebody else. And the bank just telephoned white side.
Well, I would say no. The circuit didn't say that would be a violation.
Or a gentleman.
The SEC, I think they condemned that, if I understand it correctly.
His wife bankers and Joe Parker. That they just for out all toxic to spell it up, but it's gonna be like
Right. You're right.
there's a child tell it like tell the best thing they can sell this item.
That's right, Your Honor. They do. On this basis, that there was a fiduciary relationship. And of course, I attacked that in my second reason reply to them. That's
That out.
not at all. No. Thank you.
You have 12 minutes, Mr. Neal, for
Thank you. Mr. Justice Douglas, may it please the court. Before I get into my argument as such, I might comment for the benefit of Mr. Justice Stewart that this term bellwether is not a legal term as such. It's a sheep herder's term, that's what it is. It refers to the fact that when the sheep herder discovers what the lead sheath is, the one that the other members of the flock follow, while he ties a bell around it. And then, of course, if it's dark or the weather's bad or something of that sort, why he can follow the sheep. And this really is a procedure which Judge Christensen has devised to handle these. It's just another device to handle
multiple bell cow.
Right. Now, I note from Mr. Randolph's argument that he had nothing to say about the securities aspect of the case. I remind the court, however, as I think the court is aware, that the Securities and Exchange Commission has taken a position in this case. I think it's regrettable that Mr. Randolph did not speak to that issue, because I know that this court has expressed the attitude in the past in cases such as the national securities case that it is not desirable to decide these important securities issues without receiving the benefit of the thinking of the Securities and Exchange Commission. However, they have appeared by way of their amicus brief, and I invite the court to pay careful attention to the position which they have taken, and which I might say I subscribe to completely. As far as this matter of the some legends on the stocks, which Mr. Prakash refers to, and indicated that the stock was locked up in the bank at the request of the corporations, I think this court ought to consider for a moment just what was going on here. Why would they ever even put that legend on the stock if it wasn't going to be given to the stockholder and so that he could read it and understand it? Why would they take the position that these people were fully competent and capable of managing their affairs, and that they should be held to the strict standards of accountability that Mr. Randolph would now like to impose on them, and still at the same time take the position that they weren't even competent to handle that piece of paper? It's almost as if there was some guilty knowledge involved here. It's almost as if that legend was printed on the stock to try to mitigate the circumstances that these people were being placed under. Certainly that's the view that the petitioners take, and we feel that there was a complete abdication of responsibilities here that gives rise to liability on the part of both the bank and the United States. Now, with respect to this matter of reliance, I don't think we can gloss over the matter of reliance as easily as Mr. Bertosh would like to and say that, well, it just ought to be an element of the rule. It ought to be an element of the statute, because if we look at the statute, the construction of the statute and the construction of the rule, it seems that Congress had a particular thing in mind. Congress, if it meant to say reliance, knew how to say that, and did so in other contexts. I've directed the court's attention in my brief to the provisions of Section 18 of the very same act that we're talking about. Now, I think that the Commission's position in the List case was substantially right. As I recall, they took the position that it was not really a problem in List, that as a factual matter. I've cited in my petition for certiorari the brief that the SDC filed in the list case, in which they took the very position that I'm now espousing, which is that reliance should not be an element because it leads to confusing doctrine. How are you going to prove the negative of these undisclosed facts? That's what Mr. Pratosh suggests that we should do when we go back to the trial court. How am I going to ask one of these people if they relied upon something they didn't know about? You see, that's the problem to get into. And that's why reliance is not an appropriate concept. But in Section 18, which deals with reports filed with the Commission, there's cause of action that was prescribed there for people who rely upon statements contained in those reports. Now, that's the very same act, and in that context, Congress said that you've got to show reliance. Also, in Section 11A of the 1933 Securities Act, which this court has held is in very material, Congress said that when a person brings an action based upon a prospectus, he must show reliance. Now, in this act, in Section 10, Congress didn't say reliance. They substituted something else. They said what you've got to show is that it was material. Now, material is a very nice limiting factor, too. And as Mr. Pratosh has correctly pointed out, sometimes it means the same thing as reliance, and sometimes it doesn't. But that is the term which Congress selected. I think it's the one that this court should apply. And I think it isn't the business of this court to be writing terms into the statute which Congress didn't put there, particularly when it appears in the context that Congress knew how to supply that term if they thought that it should be an element of the cause. Now, I'd like to turn to the Indian law aspects of this case, and I'd like to start off by making reference to the dialogue between Mr. Justice White and Mr. Randolph relative to the authority for the establishment of the Youth Distribution Corporation. Mr. Randolph indicated that there was statutory authority for the formation of the Youth Distribution Corporation. I submit that he was in error. There was no such statutory authority. Section 677E, which is the section which Mr. Randolph directed Justice White to, does not provide authority for a corporation. It provides authority for the adoption of a constitution and bylaws. Now, that's quite a different thing. A membership association is quite a different thing from a corporation. A corporation, the stock in a corporation may be sold. One cannot sell his right to membership in such an unincorporated association. It's almost as if one were to form a corporation for citizens of the United States and then permit them to sell their citizenship to aliens who would come to this country. To me, is an absurdity, and I think that Congress had a definite thing in mind, and by substituting the corporation for the organization which Congress prescribed, a very substantial change was wrought in the statutory scheme. It was one which resulted in the loss to these people. Now, Mr. Randolph said that it was approved by the Indians. It was approved at a meeting of a quorum of 30. Congress said that such an organization must be approved at a special meeting called for that purpose by the Secretary and by a majority vote of the adult mixed blood. That was far in excess of 30. I'm not sure exactly what the number was, but it was something like about 140. So you see, by substituting the procedures under the plan of distribution and the Constitution of AUC for the procedures which Congress prescribed, the intent of Congress was emasculated. Congress said a majority of the adult mixed bloods. Instead of doing that, they used the provisions in the Constitution which permitted a vote of a mere 30. And there's another important thing here, too, Mr. Justice White, that I think ought to be considered, and that is,
We have to get on that, but there's one in support of that. Either the diverse at a Constitution.
Constitution and bylaws. It doesn't. The word unincorporated is not in the statute. I think that's fair construction of it. However,
There could have been a plus.
well, they use the term corporation in other sections. I suppose that if they meant corporation, again, they knew how to say it, and they said it in Section 13. The fact they said it in Section 13 and they didn't say it in Section 6 is persuasive that they didn't mean it in Section 6. There's another.
Statute the authorized Constitution. Because the right is what we select as authorized subject matter silly.
That is correct. And that gets us into a whole different question, which is option 3.
The side was authorized for the legislature outside former assembly.
Yes.
And the kind of that stuff that does not to provide for the story of authorized up.
Yes, and that was provided.
That's the they stuff aids up by using a percolating that the authorized up to anyone. What the just would expect.
If we want to consider it in that way, Mr. Justice White, I'm not saying in that sense that it's inconsistent with the statute. I'm saying that as a factual matter, it didn't happen because the Constitution and bylaws provided that the authorized representative powers were those defined in Article 5, Section 1A, and those powers were never delegated to anyone. Thus, if those were the powers, they still reside where they originally were placed, with the affiliated youth citizens. There is no showing that there was ever any delegation of that power. That's a factual question, however. It's not a legal question. But the point I wanted to get to here, which I think is maybe even more fundamental than that, is simply this. This statute provided that upon publication of the rolls, every terminated youth would have his rights and severalty inheritable and such a condition that they could be bequeathed. Now, that's Section 10. It says that just as plainly as can be. Thus, at the time of this purported resolution, which Mr. Randolph refers to, there was no power for the general membership to dispose of any particular person's property because that had already vested in the individual, including the beneficial interests in the undivided assets. And I'd like to just read that section because it's
so that your old deed for authorized representative was it's a
no.
Well, you say that the undecided interest that's indirectly in the individual.
The beneficial interest.
That's all.
The beneficial interest,
all right. That's all one. And it's not no it's not to authorize anybody to deal with those sentiments.
No, absolutely not, Mr. Justice White.
They could say it's authorized.
Pardon me, I didn't cut you off.
Well, who could they as authorized to represent the individual?
Well, I suppose they could have authorized a person to do it, or a bank to do it, or possibly even a corporation, if in fact they had done that. But they did not. You see, the statute, Section 10, provides that all unadjudicated and unliquidated claims against the United States, gas, oil, and mineral rights of every kind, and all other assets not susceptible to equitable and practicable distribution shall be managed jointly. You see, we're talking about management powers. We're not talking about ownership powers. We're talking about management powers. The statute, or dispositive powers, right?
So nobody may have to authority the outside day, but it's full with this.
Not to dispose of any individual member's property. They could execute leases to exploit these resources, but they had no power to dispose of any individual member's property because they didn't own it. The individual member did. I see my time is up. I appreciate the indulgence to court. They think it's the limit.